A lot of you told me that you really liked these longer walk and talk, so we're gonna do another one. I'm out here, it's the morning. I'm with Angelica once again. She's doing her thing. Maybe you'll see her, maybe you won't. We'll see. I've been working since yesterday. I'm recording this on a Monday on my column essay for the week for the New York Times. And it's about the birthright citizenship case at the Supreme Court. Of course, I'm writing about that case. Reconstruction and the 14th Amendment in particular are big topics in my writing. And so I feel obligated to present a perspective, you might say. The case, Trump v. Barbara, really is a revisiting of the Supreme Court's holding in Wong Kim Ark in 1898. Court held, first after doing a comprehensive review of birthright citizenship in the Anglo-American common law tradition, and after unpacking the relevant phrase of the citizenship clause, subject to the jurisdiction thereof, which the court found in this common law tradition to refer to everyone who was obligated to follow the laws, which was everyone other than the children of diplomats or diplomats and invading soldiers for obvious reasons. The court held that, look, we have this tradition. The citizenship clause of the 14th Amendment codifies this tradition into the Constitution. The drafters of that amendment were very explicit that they did not view it as limited by race or nationality or really anything. The drafters of the amendment even contemplated the prospect of the clause bestowing citizenship on immigrants, and they didn't have a problem with it. So the court says it's very straightforward. The words mean what they say. We can go through all this history. We can go through all this legislative record, which, mind you, this is 1898, and so the legislative record is just 30 years prior. A bunch of the justices almost certainly knew the people involved, right? The court says the sum total of all of this is that Wong Kim Ark is a citizen. He was born here. It's that straightforward. I should say that the chief dissent in this case argued that U.S. citizenship was based on a consensual relationship. The existing citizens had to agree that the prospective citizens could be here, and that because through legislation they had said that they did not want the Chinese in the country, the Chinese could not be citizens. The majority responds to this by saying basically, yeah, we know they passed this law, but the Constitution supersedes law. But the other thing I would add, and this notably is an aspect of the Trump administration's case against birthright citizenship, this consensual view of citizenship, I would add additionally that that consensual view is essentially the view expressed by Roger Taney and Dred Scott. And one thing we know for certain, that is incontrovertible, is that the 14th Amendment was meant, or the citizenship clause was meant to repudiate Dred Scott. And so one way to look at this is how I look at it, is if your interpretation doesn't repudiate Dred Scott, it doesn't work. It might be logically plausible. You might be able to play a fun word game, fun language game to make the words say what you want them to mean. But if it doesn't do that, it doesn't work. Now, I'm writing about all of this to be able to read it in the New York Times on Wednesday. But the big reason I wanted to make this video is to make an observation. And the observation is this. So Wong Kim Ark is decided in 1898. If you know your Supreme Court case history, that year should sound significant or sound like a significant year. And that is because in 1896, the court decided Plessy v. Ferguson. The same court, this exact same court, decided Plessy v. Ferguson. And Plessy, as you might know, is the case which sanctioned Jim Crow segregation, which turned the 14th Amendment on its head. So the 14th Amendment has this equal protection clause. All persons shall have the equal protection of the laws. And Plessy v. Ferguson says, listen, equal protection of the laws does not mean the Constitution has anything to say about social hierarchies. Some people might belong to a subordinate race. And if they belong to a subordinate race, there's nothing against equal protection that prevents states from recognizing that in their law. And besides, yes, the laws say that blacks cannot be in the same train cars as whites, but it says whites can't be in the same train cars as blacks. And that's equal, that's fair. Now, I think this is specious and idiotic. and plainly subversive of the meaning of the 14th Amendment, which was meant to instantiate equal citizenship. And if you're allowing states to designate subordinate races, you are by definition not instantiating equal citizenship. But the Plessy court didn't agree. I bring up Plessy because it's striking, right, that the same court that validated Jim Crow segregation also held that the citizenship clause did not permit the country or states to create a subordinate class of people without citizenship. There was no love lost for Chinese Americans among the members of this court, but even they couldn't massage the citizenship clause into meaning something that it simply didn't say. That everything, the history, the record, the plain meaning of the words, pointed to the same answer. That if you were born on American soil, then it doesn't matter who your parents were. You are an American, unless you are the child of a diplomat, you are a child produced on territory captured by an invading army, or until the 1920s, you belong to certain native tribes. The words, they mean what they say. And even the court that said Jim Crow segregation was A-OK, even the court that looked at state laws actively subverting the purpose of the 14th Amendment and saying, it doesn't look like anything to us, even that court agreed that the words said what they mean. And so when you're looking at this current case, at this current Supreme Court, one question you have to ask is this current Supreme Court less scrupulous, more partisan, less committed to the text of the Constitution than the court that affirmed Jim Crow segregation? Unfortunately, I don't have an answer to that. I think it could go either way. But all of this is a reminder that the outcome of this case isn't really about the law. It isn't really about a question in the law. The holding in Wong Kim Ark held for the next 127 years. There was no dispute about this. And during those 127 years, it's not as if the United States was some paradise for immigrants. 26 years after the Supreme Court decided Wong Kim Ark, Congress passed the Johnson-Reed Act of 1924, which was, or is, one of the most nativist laws ever produced by an American legislature. It put harsh restrictions on immigration for basically everyone except those from Northern Europe, and especially worked to exclude people from Southern Europe, from Eastern Europe, exclude Jewish people, exclude Asians, exclude Africans, certainly exclude Africans. It was just an amazingly harsh piece of legislation. And even in the midst of all of that, of what was actually a nativist panic, no court disagreed with Wong Kim Ark. The 14th Amendment said what it meant. I'm sure there are people who wish it didn't, who wish they could redefine it, but the words say what they mean. This case is about politics, and it's about power. It's, I think, about whether the justices believe that Trump is some kind of avatar of the American people, that Trump does represent some essence of the United States, and that his commands, his wills, his decrees ought to be written into the Constitution as a kind of sovereign act. If the court has that view, which will never be said explicitly, but I think is sort of implicit in the way that it's treated Trump, in the way that it's treated his claims to executive authority, then he wins on this. If the court has at least a little fidelity to the text of the Constitution, then I don't think he does. And all of this is why it is important to engage in active political contestation with this administration, including mass protests. Mass protests show that the public is not with Trump, that his claims to representing or embodying the public are bunk, are nonsense, and that the court should probably think twice before it goes and allows him to invalidate a critical piece of our constitutional heritage. All right, I did promise Angelica or I suggested you might see Angelica at the top, and I don't like to break promises, so you'll get some Angelica time. Hope you enjoyed this one.